We've seen to have lost Spider-Man.
Check the balls.
He's not inconspicuous.
So when you come to court, you might want to give some thought to how seriously you're taking this and what you're projecting when you wear a comic book costume to come in front of a judge who can put you in prison for almost the rest of your life. You understand that? Who do we have here?
This is
Spider-Man.
Mr. Troy Tomlin on page 53 of the court's docket.
Why are you wearing a Spider-Man outfit underneath your shirt to court?
I was going for Comic-Con after this.
Okay, well, I'll tell you what let's do. Let's let you go outside the courtroom into the men's room. Take off the Spider-Man uniform underneath your shirt. Come back with a t-shirt on. At least that's a little more decent. You can always put your Spider-Man costume back on when you go to Comic-Con. Where are they having Comic-Con?
In Nashville.
And when does it start?
Around 6.
See, let me just tell you a little bit about something. I know you're a relatively, by my standards, a young man, but I'm going to give you a piece of advice. You're coming into court today, and you're facing a charge. Now, this is Mr. Tomlin, is that correct?
Yes, sir.
Pardon? And Mr. Tomlin, you're charged here with aggravated statutory rape by force, and 2 counts of sexual exploitation of a minor. So you're facing prison for an extended period of time. So when you come to court, you might want to give some thought to how seriously you're taking this and what you're projecting when you wear a comic book costume to come in front of a judge who can put you in prison for almost the rest of your life. You understand that? So you might want to think about this being taken by you more seriously. You have a very good attorney. Mr. Howard and his staff at the Public Defender's Office do the best they can do for their clients. But they can't help someone who wants to clown it up and come to court and act like a fool because they want to dress up like they're going to a Comic-Con convention on a charge like this. You're charged with sexual exploitation of minors. There's hardly other than first-degree murder, a case that I think is more serious. What are we doing with Mr. Tomlin's case?
I was going to alert the court that the state has made a plea offer. We have discussed that. However, Mr. Tomlin alerted me Friday that he would like to retain counsel at this point, and he would request more time for that.
No, I'm going to disagree with that. He's set for trial Friday. He'll go to trial Friday, or he'll accept that plea. You can decide what you want to do, Mr. Tomlin, but your case is set for trial on Friday, and I'm not going to continue it just because you decided at the last minute you didn't like what your attorney is telling you. We are taking a recess.
All rise. Courts of recess.
Mr. Howard, you any luck?
You're not going to believe this, Your Honor.
No, I am going to believe it.
We've seen to have lost Spider-Man.
Check the balls.
He's not inconspicuous.
Well, my intention was, and if we can locate him, I intend to make a condition of his bond that he not attend Comic-Con. And so you might want to contact him because I am going to put that down as an order. In my opinion, that anybody who has the judgment to show up for court with those type of charges, especially sexual exploitation of a minor and statutory rape, wearing a Spider-Man outfit, telling me he's going to Comic-Con, has no business being at Comic-Con where minor children might be gathered together. And
I understand completely, Your Honor. May we approach the state and I?
Yes.
The November date. The one we're fixing to do. Yeah, Lane Brody covered. Oh, wait, it's fine, I'll wait in just a second.
All right. Well, Mr. Tomlin has escaped the compound, so to speak, and we are proceeding with the assumption he will be going to trial on September the 22nd. And I don't know what else we had that
I
day.
was in the clerk's office.
Oh, good.
Oh, he's present.
Come on up, Mr. Tomlin.
Sorry, I was in the clerk's office making copies.
Yes. All right, Mr. Tomlin, you're set for trial on Friday. We're going to leave it set for trial on Friday. You can talk to your lawyer if you all resolve, reach an agreement. That's fine. But if you don't, we're going to go to trial. The state's ready, so you'll be going to trial on Friday. Now, the judge at this court has the inherent jurisdiction over bonding of defendants who are charged with offenses. There are a lot of factors that I consider, some of which are the likelihood of conviction, the nature of the offense that is charged. You are charged with aggravated statutory rape, rape by force, and 2 counts of sexual exploitation of a minor. And therefore, this court is imposing an additional condition of your bond pending your trial, that you will not go to Comic-Con and you will not be around any gathering of minors or other individuals, but specifically you are prohibited as a condition of your bond, in this case, from attending Comic-Con. I do that because of the nature of the offense, and anyone who shows the judgment that you have shown me today to show up in court facing these charges wearing that outfit indicates to me that you lack the substantial ability to make an informed decision on whether or not you should or should not be around those types of individuals, so I'm just going to fix it for you. You can't go to Comic-Con. If you do, I'm revoking your bond and you'll sit in jail till we set you a new trial date.
Yes, sir.
Right now, you're set for trial Friday. You and Mr. Howard can go out here and talk, and we'll see what you two work out.
Your Honor, and for the record, the state's generous offer, it only goes through Friday. If this case gets continued past this term, whatever reason, that offer will be revoked.
Well, I have a question. I have not seen the physical evidence. It's been against me. I've not seen whatever y'all have.
Not y'all, the state has the evidence. I don't have the evidence.
Sorry. And then I have a servant over me. It's my wife. She's over me. And my mother was over me, but she's no longer over me.
You have been evaluated by order of the court and found to be competent to stand trial, so you will be going to trial on Friday unless you come to an agreement with the state.
And all
Mr. Howard, take him outside, y'all talk about it, and we'll see what you do from there.
She's gonna have you fill out some paperwork and give you a card.
I have a recall on a Troy Tomlin, but that was the Spider-Man case, correct?
I think we've reached an agreement in that, subject to the court's approval.
In Mr. Tomlin's case?
Yes, sir.
two boys.
Are you kidding me? It's not funny.
Out of the building.
Check the walls.
The clerk's office. Story was last time.
I'm gonna go outside again and try to find Mr. Tomlin, Your Honor.
Yeah, that could be it.
This is for silence.
If I don't do it, if I don't do it today, then I have to do it. If I don't do it today, then it's going to be in the warrant.
We need to talk about
I'll do it today.
This is Mr. Tomlin before the court, Your Honor. Subject to the court's approval, he'd be pleading guilty to counts. I believe it's 1, 3, and 4. Double check me. Count 2, I believe, would be dismissed. The agreement would be an open plea to be sentenced at a later date. Only agreement being that they would run concurrent. Within the range, the court would decide the term of his confinement.
In Your Honor, I've spoken acknowledging with the victim and her mother. I'm talking about the likelihood of successful trial at all counts. And We talked about what the victim wishes to happen, and she is, we have her blessing on this plea agreement, and this is what she wants.
All right, Mr. Tomlin, raise your right hand. Let's place you under oath.
Do you solemnly swear or affirm that the testimony you give in this case be the truth, the truth, nothing but the truth, so
Yes, sir.
State your full name for the record.
My name is Troy Tomlin Jr.
Mr. Tomlin, you may put your hand down, please. You are here today charged with aggravated statutory rape and 2 counts of sexual exploitation of a minor, as well as a count of forcible rape. The agreement has been that the forcible rape will be dismissed, and you will be entering a plea of guilty to statutory rape and 2 counts of sexual exploitation of a minor, all of which are Class D felonies. Do you understand what you're charged with, and have you talked it over with Mr. Howard? I know I've given you a couple of opportunities today to discuss it. Do you feel like you fully understand what's going on?
Yes, sir.
Well, it's indicated that you want to enter a plea of guilty. Do you understand you have a right to plead not guilty to all charges and have a speedy and public trial by jury?
Yes, sir.
You understand that if you went to trial, you would have the right to have an attorney, to have one appointed for you if necessary. We've done that with the public defender. You understand that if you went to trial, you would be presumed to be innocent until such time, if ever, the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous. For all 12 of them would have to agree before you could be convicted of anything. You understand if you went to trial, you and your lawyer could confront and cross-examine all witnesses the state might call to testify against you, and you could bring in your own witnesses by the use of a subpoena. You understand that if you went to trial, you would be presumed to be innocent. You would not have to testify or prove anything, and there would be no inference of guilt that would arise because you did not testify at your own trial. You understand if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal. You understand that if you enter this plea of guilty, you're waiving your right to a trial and to an appeal. And all I'm going to do is to approve what your lawyers worked out. But that's going to mean that you're going to be going to a sentencing hearing for me to decide how you serve your sentence. Do you understand that? Right. You understand everything I've explained to you thus far?
Yes, sir.
Do you wish to enter a plea of guilty according to this agreement?
Yes, sir.
Do you understand if you plead guilty, the court of the state could ask you questions about the agreement. If you answer the questions under oath on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if it turns out you were lying under oath. Is your decision to plead guilty today voluntary?
Yes, sir.
Anybody forcing you to do this? I failed to mention this, but do you understand that this is going to result in 3 felony convictions that are on your record in the future that will be there to make more severe the punishment that you'll receive if you're ever again convicted of a crime? You understand that? You understand everything I've explained to you thus far? You understand I can't accept your plea unless I'm satisfied you are guilty and that there are facts to support it.
Yes, sir.
All right, we're going to do a factual statement from the state since this is apparently a best interest plea, Mr. Brooks.
Yes, Your Honor.
All right, I'm going to allow the state to tell me what their evidence is going to be, would have been at trial, so if you'll listen closely.
Your Honor, in this case would proceed to trial. The proof would show that the defendant and the juvenile that I will refer to as JB both worked at the Good Wings located here in Dixon County. They formed a consensual relationship through social media chats and subsequently had sexual intercourse at least one time behind the Good Wings somewhere in the woods. This was later, the defendant later made admissions to such in an interview with police. A search of the defendant's phone produced an image and a video of the victim, who was 14 years of age, and she was nude, showering in both the video and the pic. All this happened in Dixon County.
All right, I'm not asking that you agree with those terms, Mr. Tomlin, but do you understand that's what the state's evidence will be if you went to trial on these charges?
Yes, sir.
Do you wish to still enter a plea of guilty according to this agreement?
Yes, sir.
Are you satisfied with your attorney's services?
Yes, sir.
I feel like Mr. Howard has done a good job of representing you competently.
Yes, sir.
Howard, do you know of any reason you should not enter this plea?
I do not, Your Honor.
All right. Then Troy, anything further?
Your Honor, has the sex offender registry been mentioned?
It will have to be as a part of the sentence because of the nature of the charges, regardless of how he serves them. He'll be on the sex offender registry according to the law, and that will be obviously a requirement of this. Any questions, Mr. Howard?
He was asking about court costs, Your Honor. I told him we could switch.
Well, that'll be part of the sentence that's imposed as well. All right. Then Troy Allen Tomlin Jr., upon your plea of guilty to count one, I find you guilty. Order that you be required to serve the sentence that will be determined by this court to be served at a sentencing hearing. Count 3 and count 4, count 2 being dismissed. In each of those cases, he will be found guilty and the sentence will be imposed at a sentencing hearing. By agreement, the counts will all run concurrently, and because it's a range 1 offender and they're all Class D, the term will be between 2 and 4 years. That will have to be determined how it's to be served. Is he going to remain on bond pending his sentencing hearing?
Yes, sir, if the court would allow it.
You know, we had the Dixon County State versus Paul Garrett rape trial motion set on the 8th and 9th. Are they still a go as far as we know?
I think so, Judge.
And then do you expect, this is your local counsel, I think, on that. Is that for sure going to take full 2 days?
It'll take a full day.
It will not take the state long. I don't know how much the defense will put on.
Well, we've got them set for 2 days on the 8th and 9th of November. So what I'm wondering is if I could set this sentencing hearing on that 9th of November.
I have down, I think, the 8th and 9th as well.
All right, so is it a 1-day motion hearing?
My calendar had both 8th and 9th blocked off, but I personally don't think it'll take that long, but I think Mr.
I had on my
Potter's-
calendar for the 8th, but
Sounds like we'll be done the 8th then.
Well, can we do this on the 9th?
I think that should work, Your Honor.
Mr. Brooks?
I'll be available, Your Honor.
All right. We'll put it at 9 o'clock on the 9th. Tomlin will be sentenced according to the precinct, get an order of pre-sentence report and do the sentencing hearing at 9 o'clock on November 9th.
Sir, thank you.